Remember, you are ultimately responsible for protecting yourself and for providing for yourself. Live your life with honor and integrity, and always be the wolf hunter. Don't be the sheep, nor the wolf. In this video, I want to discuss the Stand Your Ground law and also its opposite, the Duty to Retreat law. But first, the disclaimer: before using anything in this video as advice, research the laws and also the court decisions in your state regarding the use of force and protecting yourself. Each state has different laws that could affect you should you use force to protect yourself. This video simply reflects what my opinion is of the two different laws. And remember, you are responsible for protecting yourself and making sure that you do it legally in your state. But some high profile cases have been in the news in recent history that have brought to attention to the Stand Your Ground law, one particularly being the shooting death of a Trayvon Martin by a George Zimmerman in the state of Florida. When this case was being plastered everywhere by the media, the Florida Stand Your Ground law came into light, and this naturally brought up the fact that many other states also have the Stand Your Ground laws. And of course, when liberal people learned of the Stand Your Ground law, and when they couldn't fathom how an armed adult man could shoot a teenager that seemed to be armed only with candy and a tea, naturally the liberals voiced their displeasure with such a law and started making silly comments that the Stand Your Ground law actually legalizes murder. Now, I may be incorrect on this too, and do correct me if I am wrong, but I believe that that Zimmerman's defense team didn't even claim the Stand Your Ground law, but many liberals still voiced their dislike of the law and how they thought that the law should be done away with. Because it always seems that liberals don't like people being able to take care of themselves, and they always seem to believe that criminals should be coddled and that the state should take care of all of your needs. But right now I don't want to discuss the Trayvon Martin and Zimmerman case. That discussion will come later. Right now I want to discuss the differences in the two different laws, and I wanted to give some definitions. Definition number one being the use of force. This can be defined as the amount of force that a person uses against someone else. This term generally would be used in the case of force that is used that doesn't cause death or the possibility of death. A citizen punching an assailant that just punched the citizen would be an example of regular use of force. Definition number two, deadly force. This is the use of force that causes death or could cause death. A citizen that shoots an assailant that has threatened the life of that citizen would be an example of deadly use of force. But basically, in a nutshell, the Stand Your Ground law in many states say that if a person is legally where they are at, and if that person gets assaulted or attacked, then that citizen that is legally where they are at and has no duty to retreat, then that citizen can use reasonable force to protect themselves where they stand. On the other hand, the duty to retreat law usually states that a person who is legally where they're at has a duty to try to leave the area to defuse that situation if they start to become accosted or threatened, and can use force only when cornered or when there is no escape, especially in deadly use of force cases. Now, here are some of the reasons why I believe that the Stand Your Ground law better protects citizens rather than the duty to retreat law. If a citizen is legally at a location and is partaking of illegal activity such as walking in a parking lot or shopping inside of a store or inside at their home, then the duty to retreat should solely be on the criminal and not the law-abiding citizen. It is my belief that the duty to retreat law helps protect the criminals and places an extra burden on the citizen who is facing a sudden threat. We have to remember that assaults are usually pretty sudden and violent and confusing for the assaulted person. And to have a law expecting a regular untrained citizen To have their total wits about them during a stressful situation where their safety or life is in danger again helps protect the criminal, not the law-abiding citizen. We also have to remember that the people that will judge whether a citizen had the ability to retreat will be making that judgment while they're sitting inside a sterile and calm environment, such as a courtroom or the prosecutor's office. Many of these people judging the citizen's actions have never been in a truly violent encounter before, and they forget that while they're judging the citizen's use of force actions, that they're able to sit and ponder everything in the relaxed environment that they're in. I see this time and time again, especially in the remarks section of a controversial video that's been posted on YouTube or Facebook. People forget that a person in a violent situation perceives things differently and processes differently what they are observing when their safety or their life is at risk, compared to if they're sitting in a relaxed environment and watching a video. A person can only really truly judge another person's actions in a violent situation if that person has been in an encounter exactly like the other person was in. It is my belief that anybody put into the position to judge another person's use of force actions should ideally be people that have either been in a violent assault themselves or that regularly train in fighting and hand-to-hand combat. We also have to remember that too many people don't understand that a bad guy can cover 21 feet in just 1.5 seconds or so. If a person is expected to try to turn and either run or go through a door or to get into their car, chances are the bad guy is already going to be on top of them before the law-abiding citizen has time to turn the handle or on the doorknob or to get up that flight of stairs or to get their car door open, etc. For example, if a state has a law that says if a homeowner finds an intruder in his house, and if the homeowner has a door that he can escape through, then the homeowner is required to try to go out that door before using deadly force. However, since a bad guy can cover distance so quickly, more than likely the bad guy will be on top of that homeowner before the homeowner can effectively escape out of that door. I believe that the duty to retreat law may make this law-abiding citizen find out the hard way that their escape would not be successful. The law-abiding citizen should not be placed in harm's way by requiring them to try to escape first. The law-abiding citizen should only be required to take the steps that help ensure his or her safety and the best chances of getting through the encounter unscathed. My belief is that we should only be interested in the well-being of the honest citizen and not the criminal. Also, the stand your ground law does not legalize murder. The stand your ground law only allows deadly force to be used if the citizen feels that his life is in danger, and does not allow deadly force if the suspect isn't offering deadly force. I know that liberals have come up with some statistics that say that states that have passed stand your ground laws have had an increase of shootings where the shooter is not charged. I have not researched these supposed stats, as I have a full-time job with overtime and a house to take care of, a family, and training that I also give and that I also take. But since the stand your ground law does not allow people to just start shooting anybody that doesn't pose a life-threatening risk, I really think that they're pulling some trumped-up stats to try to further their agenda. Their agenda, which seems to be to coddle the criminal instead of holding them responsible for the actions. Or it could be that the stand your ground law is actually working and citizens are now more able to legally protect themselves when faced in a deadly situation. But here are some tips to consider when faced with a possible assault from a stranger. Even if your state has a stand your ground law, if you can, do try to retreat out of that situation if you can do so without putting yourself at greater danger. If you can get out of there without blows being exchanged or without someone being shot or killed, then do so. Doing this helps to show in a court of law that you were not a willing participant in the situation and that you were forced into whatever actions that you took. But all steps that you can take to show that you were not a willing participant, that you were not wanting to engage in mutual combat will help show your use of force. Will help your use of force get challenged in a court of law. Only use deadly force or shoot someone to save a life. Never shoot someone just to take a life. This means that you use deadly force against someone because you were forced to, because they left you with no other option. This does not mean that you try to aim for the criminal's foot or something like that. That is a bad target to go for in a high-stress, deadly situation. It just simply means that you only shot the bad guy because you didn't have any other option. But if you do shoot only to save yourself or to save someone else's life, most of the time you will be okay, provided that you don't live in a real liberal state where they usually don't like it when honest citizens protect themselves against the criminals. Now, when you shoot someone to save your life, there is a real chance that the bad guy will die from his wounds, but that should only be a byproduct of you saving your own life or someone else's life by stopping the bad guy from continuing with his actions that are posing a deadly threat to you. Also remember that the deadly use of force should always be a last resort and never just a convenient option. And use voice commands and articulate what your intentions are if possible. Yelling, "Stay back," or "Drop the weapon," or "If you don't stop, I will be forced to shoot." It does two things. It tells the bad guy what your wishes are and what you want him to do, and it also may produce witnesses for you that would testify on your behalf should your use of force be challenged in court. Now let's touch quickly on the Trayvon Martin and George Zimmerman case. Too many people just could not fathom how a grown man could shoot a young man that was armed. First, I'd like to articulate that none of us can truly, totally judge what happened that night in Florida, since we weren't there and none of us didn't personally witness what happened. All we can really go on is what the evidence showed, which seemed to show that Zimmerman was getting his head bashed into a concrete sidewalk by Mr. Martin. If that was truly the case, that Mr. Martin was on top of Mr. Zimmerman and was beating his head into the sidewalk, then Mr. Martin was not unarmed. He had actually armed himself with that concrete sidewalk. Instead of bringing concrete to Mr. Zimmerman's head, he was taking Mr. Zimmerman's head to the concrete, which obviously could have resulted in the severe bodily harm to Mr. Zimmerman or even his death if Mr. Martin opted to continue those actions once Mr. Zimmerman would have went unconscious. So if that's truly the case, that Mr. Martin was using that concrete sidewalk as a weapon against Mr. Zimmerman's head, then it appears to me that it was a good self-defense shooting. We should realize that even if Mr. Zimmerman was not supposed to be following Mr. Martin when he suspected him of being a possible burglar, that the evidence appears to show that Mr. Martin disappeared out of sight and therefore was no longer in danger, and then it appears that Mr. Martin then possibly ambushed Mr. Zimmerman. Had it had been the other way around, that Mr. Zimmerman began using deadly force against Mr. Martin for only being a suspected criminal who was not an active threat to anyone at that time, then Mr. Martin could have used deadly force to protect himself against Mr. Zimmerman, because in most states you cannot use deadly force to protect property. But to reiterate, none of us can truly judge what happened that night since we were not there and did not personally witness it. All we can do is to go by the evidence that has been released to the public. We need to remember that there is a huge difference between a stranger starting to engage in an unprovoked attack against you, the difference between that and a schoolyard fight between you and one of your classmates, or maybe an argument with one of your family members or a coworker over a silly dispute. Not knowing someone, having a stranger begin an unprovoked attack, this situation more than likely means that you don't know the true intentions of the stranger that's getting physically violent with you. You don't know what his intentions are, and how far he's wanting to bring injury to you. You have no idea if he's going to stop once he knocks you down, or if he'll continue his assault once you're down until you're either very seriously injured or dead. Also, in most states with good self-defense laws, you are able to use deadly force against someone, especially a stranger who has attacked you and is about to render you unconscious. However, when you know someone, such as a classmate or a coworker or a family member or somebody else who that's decided that they're going to throw a punch at you, chances are that you're going to have a pretty good idea that their intentions are just to purely beat you up and not actually kill you. This is a case where you probably cannot use deadly force and just need to accept the butt whooping or use regular force to defend yourself against that other person's punches. Remember that you never want to be the instigator of a fight or a confrontation. You should always be upright in your life and seek peace. If you end up in a confrontation, it should purely be on the actions of someone else rather than you. We should also remember that weapons are equalizers, especially against attackers that may be larger, stronger, or armed with a weapon themselves. We should also remember that even if liberals could wave a magic wand and make every gun on the planet disappear, that attackers will still arm themselves with impact weapons or edged weapons. If a citizen is faced with an attacker that has an edged weapon, then that citizen should be armed with a firearm. You never want to be armed with an edged weapon against an attacker who's also armed with an edged weapon. If the liberals want citizens to stop buying guns, then the liberals should join how most conservatives believe, and that is being that taking violent criminals off the streets instead of coddling them will help make our streets safer. Once people start feeling safe, they'll stop buying self-defense weapons. So just to recap this video, the stand your ground law does not legalize murder. The duty to retreat law does place an extra burden on a law-abiding citizen that's already facing a tense and uncertain situation. And always remember that violence and the deadly use of force should always be a last resort and never just a convenient option. Folks, if you found this video to be informative, then please like the video and comment below, and also please consider subscribing to this channel, as I plan on making many more videos down the road as time permits. Anyways, folks, if you made it this far, thank you very much for watching, and I hope you have a good night.